Hi, everyone. My name is Allison Grosz. I'm a partner and an attorney with Hemrick O'Malley, PLLC in New York City. Today, I want to talk about a recent Supreme Court decision that was handed down last week. The name of the case was the Department of State versus Nunez, and what the case was about was a legal concept that we in immigration know as consular non reviewability. Now, what the Supreme Court decided on was ultimately whether or not the U.S. Department of State, the U.S. consulates, and a consular officer abroad is allowed to deny a person's immigrant visa application, which means a green card application from abroad, without giving any logical reason or connection or even an explanation for the reason for the visa denial. Now, this may sound really odd to a lot of people who don't know the way that the U.S. government and the Department of State specifically works. There has been a long-standing concept in the U.S. immigration policies called consular non-reviewability. And what it effectively means is that in traditional immigration contexts, a U.S. consular officer, meaning someone who is employed with a consulate abroad with the Department of State who interviews somebody in their immigrant visa application, can deny that person's immigrant visa application without giving any reasons or explaining the reason for denial. Now, of course, this is very problematic for a lot of people because how do you overcome a denial for something that you don't even understand or know the reasons why they reached that decision? Now, this case was brought before the Supreme Court several years ago. It's been fought all the way through the entire federal court system, all the way up to the Supreme Court. And the Supreme Court ultimately decided that consular non-reviewability prevails and that the Department of State and the consular officers do not need to provide an explanation to a visa applicant or their U.S. citizen family members when denying a visa for a person to come to the United States and join their family in the United States. Now, of course, this seems really problematic, and this is an unfortunate decision that we were hoping not to happen. Why am I talking about this today? I'm talking about this because in our office at Hemrick O'Malley, we file quite a few cases called writs of mandamus, which I've talked about in prior videos from several months ago. We can always file a writ of mandamus, which is basically a complaint to the federal courts about something that we disagree with or a delayed adjudication from any U.S. government or immigration official. Now, we file a lot of these writs of mandamus based on delayed adjudications of either immigrant visa applications abroad or any petitions or immigrant visa applications here in the United States. We still can file writs of mandamus or any other federal complaint about the reasons for a denial from abroad, from a consular. However, this decision from the Supreme Court, of course, creates an already uphill battle to be that much more steep. I don't want this to discourage anybody from feeling as though if you have been treated unfairly by a U.S. consular decision, or if you think that an unfair decision was reached, this doesn't mean that we cannot ask for reconsideration, that we cannot fight it in some way. We here at Hemrick O'Malley, PLLC, are willing to fight all the way, even despite a Supreme Court decision case, on somebody's unfair treatment or what they feel is an unfair denial of a visa application, whether it's here in the United States or whether it's from outside of the United States at a consulate abroad. We're happy to answer any questions that somebody may have about these matters, about the recent Supreme Court decision in Nunez, or about any other immigration matters. You can find us online at hemrick.law, or you can reach us by phone at 833-848-7838. I look forward to talking to everyone again soon, and until then, be well.